I haven't seen Dr. Wang, Professor Wang. Is he available now in the virtual room?
Professor Jin or
Wing.
which one?
Wing.
Wen.
Yeah.
ما في صوت ما في صوت.
انت عامل صامت يا عمار. اوكي.
دكتور عمار سمعنا؟
دكتور عمار مسموع الصوت؟
الو؟
سامعينك دكتور عمار تفضل. دكتور عمار you are co-host and unmuted.
Okay, then I think we have to start. جاهز دكتور إبراهيم؟
جاهزين دكتور تفضل.
السلايد عندك جاهزة؟
هاي ما عندي سلايد هاي.
مش شايف السلايد دكتور إبراهيم.
تمام هيك دكتور واضح؟
ما عملت شيرنج للسلايد.
واضح هيك دكتور؟
So.
Yes, good evening from Jordan to everybody. I would like to welcome you again from the virtual room of the Regional Center for Space Science and Technology Education and IWAS, Arab Union for Astronomy and Space Science. Actually, this virtual room, it's in cooperation with many institutions and organizations who deals with astronomy and space in Arab world, like Arab Union for Astronomy and Space Science, Sharjah Academy, Space Science and Astronomy, National Institute for Astronomical and Geophysical Research, and National Authority of Remote Sensing and Space Science, Egypt. Also, College of Navigation Science and Space Technology, and many other organizations. It gives us a great pleasure at the Regional Center for Space Science and Technology Education and the Regional Center for Space Science and Technology Education, China, Asian Pacific, to give this very important lecture under the title of GNSS Civil Liability. Today will be actually with Professor Q. Jia she is a Deputy Director of Space Law, Institute of Law School in Bihang University. And she is supervisor of master and supervisor of master program for the Regional Center for Space Science and Technology Education in Asia and the Pacific in China, which is affiliated to the United Nations. She received PhD in International Law at Graduate School of Chinese Academy of Social and Science. Her major research interests are outer space law, national navigation regulations, and private international law. She has taught Chinese legal system course for 1 credit in USA for Juris Doctor candidate. She was awarded as the best tutor for Manfred Latz International Space Law Moot Court Competition, China region. In your behalf, I would like to welcome her again, and really we are very much grateful to our partner, the Regional Center of Asian Pacific, who is cooperating with us in these actually activities. And please Professor, it's your floor to start your lecture. Thank you very much.
Thank you for the introduction from the president for me. It's my great honor to be here to share my opinions on this topic, GNSS Civil Liability. You know, I am the law faculties. I'm the faculties of law school of Beihang University. So during the past 10 years, my main research fields is about the outer space law and national regulations on GNSS. So that's the reason why I choose this topic to share with you here. Now, please allow me to share my PowerPoint here.
Okay.
So I have shared my PowerPoint. Could you see it? Is it clear?
Yes.
Yeah, it is.
Okay. If you permit, I will start from the very beginning about GNSS civil liability. Also, okay. As we all know, national security, economic growth, and transportation safety, as well as efficiency, are seriously dependent on positioning information, navigation capability, and the time dissemination provided by GNSS. That is only one side of the coin. The more humanity depends on GNSS, the more risks it has to face. A defect in or a loss of GNSS signals occurring due to unintentional or intentional causes may not only endanger hundreds of lives on board of an aircraft, which is based on a GNSS landing system, but it may also cause substantial economic loss to critical civilian infrastructures for banking, electricity, and other purposes. So the question is, who will be responsible or liable in the event that real damage is caused by GNSS to its users or any third parties? And how shall such be responsible or liable? The international community has contributed decades of efforts into searching answers. So far, no consensus has been reached. Some believe that there is nothing that exists in a legal vacuum, and that the current international law regime could deal with the issue of GNSS civil liability, while others doubt on this. They say that whether the fitness of our law to such new technologies. That's the reason why.
Start your presentation. Start your presentation. Launch your presentation. Your presentation, please. Start it.
I'm sorry.
Launch your presentation. Make it larger.
Sorry, not working.
Can you please just
louder, right?
No, launch your presentation. Make your presentation full screen.
The slides in the presentation is fixed. Please, you can move it on.
Okay, I'm. Yeah.
Yeah.
Is that okay?
Yes. Just you. Okay, that's fine.
Okay.
Can you make
okay?
F5,
Thank you.
F5? Can you F5 on your keyboard?
Is that okay?
Not yet. Yeah, that's okay.
Okay, thank you.
Thank you.
Oh. Okay. So today we are going to explore whether current international law is adequate to deal with the issue of civil liability in the context of the GNSS. If it doesn't apply, where is the legal gap and how should we move forward? So this is not the slide I talked about. Sorry, here. So today, I would like to proceed in the following 4 parts. The first part is about the overview of the GNSS, mainly about the risks GNSS facing and the scope of the lecture. The second part is about the national law for GNSS civil liability. This is from the perspective of national law. And the third part is about the international space law for GNSS civil liability. This is from the perspective of what does the international law say. And the last part is about the summary. So this is the whole structure of my lecture. Now let's move from the first part. It's about the overview of the GNSS. I have heard from Professor Jing that they had offered several lectures on the structure and the function of the GNSS. So I will omit this part and move to this part, because GNSS as we all know, GNSS presents opportunities for increased safety, security, and efficiency. But all of that must be secured by accuracy, integrity, availability, and continuity requirements without malfunction, degradation, and harmful interference. Unfortunately, GNSS is now facing technical, financial, institutional, and legal risks, which are potential causes for accidents. Now let's start from the first. Risks. It's about the technical vulnerability. You know, it is very hard to guarantee the expected services or signals around the clock, while GNSS inherent error is restricting its accuracy and integrity. The most notable area of concern for users is legal or illegal interference, which is challenging GNSS continuity and availability. In addition, GNSS has its technical limitations. For example, GNSS signals are unable to penetrate buildings, water, and other obstacles, which make it rather difficult to construct a seamless satellite navigation environment in a metropolis or in valleys. So that's the first one. First risk GNSS is facing. The second one is about the finance pressure. As we all know, there is an example. The fully operational freeze of Galileo has been postponed repeatedly from 2008, mainly due to the financial crisis. While the direct use of open signals is free of charge, GNSS investors have little opportunity to get a return on their investment in the near future, let alone potential profit. This led to the Galileo's public-private partnership approach falling apart in 2006. Although the US government commitment to provide GPS standard positioning service signals on a continuous worldwide base, free of charge. This was subject to the availability of funds, which means if there are no funds, there are no promised signals. This is the second risk GNSS face. The third is about the institutional challenges. According to US selective availability policy before 2000, and the modern concept of navigation warfare, political or military conflicts may lead GNSS providers to shut down their military or civil signals, to deny hostile use in the area of military operations. This consideration was the exact motivation for Europe and China to develop their own GNSS, which is Galileo and BDS. In addition, GNSS management problems can't be ignored. Good mechanisms for spectrum allocation are a precondition to ensuring good access to navigation signals. Also, incomplete supervision of staff, inadequate training of personnel, unreasonable workflow, and human fault in the operation of software or hardware may cause a GNSS incident or accident. So as we talked about, those are the three mainly risks GNSS may face, which will lead to the accident, which means that may lead to the liability. This is the GNSS risk part. Now let's move to the next part. It's about the scope of GNSS under the term of GNSS Civil Liability. Before we move forward, we should make it clear the definition of GNSS. Technically speaking, only a satellite navigation system with global rather than regional coverage can be defined as GNSS, which is but RNSS is technically independent of GNSS with its standalone system constitution and with the transmission of its own signals. However, in the legal sense, there are something in common. RNSS and the GNSS has no essential difference in terms of civil liability issue. In fact, the major difference between GNSS and the RNSS is coverage. The former is global and the latter is regional. Even for RNSS, its scope of service usually covers more than one state, which is also a form of international. This means that RNSS legal issues are involved in different jurisdictions as well, just as the fundamental feature of GNSS civil liability. But for the national navigation satellite system, it's different because no global or international factor involved in this, and it's usually only related to domestic legal systems and has nothing to do with the international law. That's the reason why the definition of GNSS could include the GNSS and RNSS, but exclude national navigation satellite system. Okay, this is the first definition I want to make clear. But the second one is about someone may say GNSS augment system. What about this system? From the perspective of providers, the role of an augment system is to aid GNSS in improving its accuracy, integrity, and availability. And it is not inherent part of GNSS itself. ICAO also confirms in its definition of GNSS and the introduction of GNSS elements. Therefore, an augment of GNSS and it hence falls under the concept of GNSS Civil Liability. Okay, those are the content should be excluded from this definition. Are GNSS value-added services. A typical example of this is the navigation service provided by Google Maps or its competitors. It is reported as navigation problems frequently. For example, there are some news about 9-car accident caused by Google Maps and GPS. So what GNSS transmission to the receivers is only the signals that contain PNT information rather than map data. Therefore, the liable party in those cases are map providers rather than GNSS providers. If the damage in the navigation were caused by the loss, degradation.
Will you please, Professor, can you move the slides? The slide
No,
is...
sorry. Here, I still talked about this one.
Okay.
I still talked about this one.
That's fine.
Okay.
That's fine. That's fine.
Okay. So I just talked about the GNSS value-added services and the reason why it should be excluded from the definition.
That's fine.
Because this value-added services, the map providers should be liable for the damages, not the GNSS providers. So we exclude this situation. And another scenario is the malfunction of user equipment. Although according to the constitution of GNSS, user equipment is an essential segment of GNSS. Liability arising from the malfunction of user equipment is legally and generally speaking not GNSS civil liability. First, an end product. The receiver receives GNSS signals, which then computes its location. If the PNT data offered by GNSS complied with the requirements, but the receiver computes the data wrongly, so the defective receiver or software may apply to general rules of tort law or product liability. Second, the production and the sales process of user equipment are conducted by other legal entities. In other words, GNSS providers are not the manufacturer, owner, and controller of GNSS user equipment. In summary, GNSS civil liability includes liability triggered by core GNSS, augmentation systems, and regional systems, but it excludes GNSS value-added service and the malfunction of user equipment. So this is I have finished the first part. overview of the GNSS. It's just a briefly introduction about the risks GNSS may face and also the scopes of GNSS. No questions. I would like to move to the second part. Okay. So second part is about the GNSS civil liability from the perspective of a national law. So here, I post the definition here. The obligation to make reparation for any damage caused, especially in the form of monetary payment by the inappropriate PNT signal provided by GNSS, augmentation system, and the regional system, but excluding GNSS value-added service, the malfunctioning of the user's equipment. So this is the whole definition about the civil liability arising from GNSS. So from this chart, we can see may arising from the GNSS. There are mainly two types. One type is the contractual liability. Another part is the non-contractual liability. Under the non-contractual liability, we can divide it to several types. Also, for the first part is the tort liability, and one is third-party liability. So the category on the national regulations is different between the common law systems and the continental law systems. So it depends. So discussion above, I would like to clarify the respective relationships of different concepts under the framework of GNSS civil liability. So in order to establish GNSS civil liability and be able to benefit it from the court, certain elements should be proven. So I listed the 4 elements. Let's take a look. Usually, if you want to prove someone broken the obligation, you should prove 4 things. The first one is the party involved. The second one is the reasonable acts. The third one is the damages. The fourth one is the causality. That's the link between the acts and the damages. So we'll elaborate. So could you hear me clearly here? Hello? Could you hear me?
Yeah.
Okay. Okay. I would like to, may I proceed? Okay. Let's take a look at the first part here. The first element is about the GNSS parties. Usually, the parties, GNSS parties will involve providers, users, and the third parties. For the GNSS providers, assigned transmit, including but not limited to the owner, system constructor, and the operator. Currently, most actors from the supply side in the value chain of the GNSS are public in nature, while some private contractors or suppliers may be directly involved into court proceedings, particularly in the case of product liability. Furthermore, if a GNSS signal is recognized as a product in court proceedings, those parties in each link of the chain would be held liable as either manufacturer or seller. This is the provider. But for the users, as we all know, according to what GNSS providers service, a GNSS user could be categorized as either an open service user or an authorized service user. While the eligibility of the authorized service user as a possible claimant is usually recognized on the basis of contractual relationships. In the case of the open service user, it is difficult to find the legal basis. So in addition, the term GNSS user is a multi-level concept. In other words, before a GNSS signal is finally transmitted to its terminal user, each provider compared with its downstream user is also the signal user of its upstream provider. And they can be called as first user, second user, and so on to the final user. The final point that needs to be addressed in the international characteristic of GNSS users make a big difference in identifying the claimant and the jurisdiction in the case of GNSS civil liability. This is mainly, the GNSS parties mainly involve two parties, providers and users, but sometimes it may involve third parties. A third party is beyond any relationship or transaction between the other two parties. As the victim who suffered from GNSS damage, a third party could be the subject of third-party liability. As the source of frequency interference against the GNSS signals, a third party could potentially be the liable party. So this is the parties involved. Next one. It's about the triggers. Unreasonable acts. Unreasonable acts. GNSS are facing technical vulnerability, financial pressure, and institutional challenges, as we talked about. But can all those elements be transferred to the triggers of civil liability? The answer is no. There are two typical cases here. The first one is the state-of-art technology. As we know, no matter how advanced the GNSS technology is clear to be, it will always have a gap between real and ideological condition. A technical defect, which is beyond the current practical technological feasibility, is free of civil liability, even under the regime of strict liability, namely product liability. So if we, this is the state of art technology. And the second one is the act of God, When we see this name, act of God, we may imagine that, GNSS signals pass from the near vacuum of space, and then through the various layers of the atmosphere to the Earth. In doing so, it will likely to be influenced by uncontrolled space weather, such as ionosphere and solar activities, which could lead to the inaccurate or total loss of PNT signals, and therefore cause damages. Except for those scenarios, similar situations may also occur because of earthquake and other natural disasters, which may destroy the ground facilities of GNSS. In general sense, no one may be liable for those events because those are out of the human control. This is the second triggers. And the third triggers is wrongful act or omission. Generally speaking, civil liability will arise only upon the proven existence of the fault of the obligation person, which may be expressly by act or omission. In the context of the GNSS, civil liability is triggered by the failure of the GNSS signals, including the absence of signals, the error of signals, and all the degradation of performance. The causes giving rise to the failure of GNSS signals can be summarized as follows here. The first one is system malfunction. Just like, it happened in 2009, there is a collision, system shutdown, or more possibly partial signal cut off, and incorrect uploading of data, organizational problems, and other malfunctions that could be attributed to the provider's intention or negligence. So this is the first scenario. And the second one is harmful interference. This refers to the radio frequency conflicts from jammer and spoofing devices. In particularly, the low-cost, low-priced ones, which are usually willfully or unintentionally used by third parties, including but not limited to the government authorized service providers, operating forces, criminals, or even worse, terrorists, etc. This is the second one. And the third one, non-performance. Non-performance. This term is limited to the failure to perform an agreed obligation in a reasonable manner. For example, breach of contract. To judge non-performance in the context of GNSS, the court expert witness would need to proceed from the four performance parameters, which are accuracy, integrity, continuity, and availability. So, if a GNSS provider itself forced to comply with required and promised performance parameters, the provider would be considered to undertake the contractual liability. So this is about the non-performance, which is to say, if you promised to keep accuracy, integrity, continuity, and availability, you should fulfill your promise. Otherwise, you will breach the obligation of the contract. And the next one is the defects in GNSS provision. As one form of typical strict liability, product liability seems never to take into account whether it is the manufacturer's or the seller's fault. The victim may claim for no fault liability for the damages caused by the defective GNSS equipment or signal services. However, whether that GNSS provider can be labeled as a service, product, data, information, or just a signal remains open. Okay, the above mentioned are the scenarios for the wrongful act or omission. This is the second element to prove the liability. Now we'll move to the third element to prove, which is the damages. As we all know, damages is very simple. We can clarify from the appearance. For the satellite navigation, satellite communication, and satellite remote sensing are three critical applications of satellite with the same importance. But why civil liability is a topic concern of satellite navigation, but not an issue in other satellite communication or satellite remote sensing? Do you ever think about this question? So here is a question. When we talked about the civil liability arising from the GNSS, but why don't we talk about the liability arising from satellite communication and the satellite remote sensing? Is anyone ever think about this question? Anyone want to respond or communicate with me with this question? Okay, if no, I will answer this question by myself. Okay, the reason behind this phenomenon is the gapping differences on the extent of damage caused by each of them. Unlike satellite communication, the service based on GNSS is related much more to safety of life, especially in the transportation and the search and rescue sectors. Even though these can also connect terrorists by easy spoofing devices. Moreover, safety critical applications of GNSS usually need more real-time data than satellite communication, especially for high-speed mobile vehicles such as landing aircraft. Likewise, satellite remote sensing is actually a space-based monitoring system, which is not capable of mitigating ongoing disasters. The reason why GNSS has more to do with dangers lies in the fact that it can play the role of the controller of autopilot aircraft and other decision-making systems, whereas satellite communication and remote sensing are usually the assistant tools of the controller's decision. Okay, that's the reason why we usually talking about the civil liability arising from the GNSS, but seldom talked about the satellite communication. So as to the damages, as to the types of damages caused by GNSS, there are five categories. First one is personal injury. This is a key issue. Whether mental injury is included should be decided by the national laws. Economic loss, including the property damage and the delay of goods or passengers because of the GNSS malfunctioning, in particularly in the civil aviation sector. So this is about the personal injury. A second one is the, okay. I also finished the economic loss here. And the third one is about the environmental damages. For example, if the GNSS caused the collision of vehicles transporting oil, nuclear, or other dangerous materials, or danger to the nuclear vehicles itself, it will cause the environmental damages. And the fourth is privacy leak. Because, you know, it may caused by an unlawful GNSS data leak from a provider or because of system-related reasons, such as the suffering a hacker attack rather than the legal use of GNSS equipment. It will lead to the privacy leak. And other types of detrimental effect. Okay, this is the types of damages. Now we'll move to the next part. It's about the carrier link. From the above, we talked about the parties, unreasonable act, and the damages. Now we move to the another mood to prove that all those things have some, you know, links among them. So here is the question. Please hear me. Can radio signals really hurt people directly? Can radio signals really hurt people directly? The answer is no. The answer is no. Unlike an tangible object, a radio signal is tasteless and colorless, the existence of which we are even unable to ensure unless we use special devices. So technically speaking, satellite navigation signals are soft, and this is decisive in determining that those signals could never hurt, hit, or collide with people and their properties. That is why the carrier link in the case of GNSS is usually not apparent. However, there is civil liability for the damages caused by those signals in the legal sense. The term caused doesn't require direct physical contact or connection, like damage caused by a wrong information service, such as defective software and aeronautic chart as long as the radio signal is one of the reasons for damage. We can say that a carrier link exists. Another example. Let's say a car accident caused by the failure of the brake system to work due to the defective design. This failure of the brake system links damage to manufacturers. This brake system links damage to manufacturers, even though the brakes never touches the victims. So, to be qualified as a causer of damage, the causal link between GNSS signals and the defective information, brake failure, and other issues has to be proven via the pathway of middle tools, such as vehicles in transportation. For example, in the case of economic loss of banks caused by wrong GNSS timing data, computers. What GNSS Civil Liability addresses in the consequences of GNSS signal rather than the signal or the middle tool itself. After we talked about so many, the real challenge in the case of GNSS liability is to prove that the damage in question was actually caused by GNSS. You can imagine how you prove the damage was caused by the GNSS. Could you prove it? You can imagine what kind of evidence could you find? In my opinion, it's really hard to prove because I am not the professor in GNSS. I know little about the technical or function of the GNSS. That's the reason why I'm really hard to prove the GNSS caused the damage. As we all know, the GNSS is a high technology. To most of the persons, it's really hard to understand. And also, the GNSS signals update second by second. It is possible to store them unless the conduct monitoring is agreed in advance and the records are kept. So this is the technical nature determines the difficulty of proving the failure of GNSS was the contributing factor or one of the factors to the damages. Furthermore, if an accident is, it is usually various accumulated factors coming together at one time, rather than just one element may cause the accident. So all those elements make it very hard to peel the failure of the GNSS away from the other factors. The above is particularly true for a claim based on tort law, which has a substantial causality requirements, contrary to the contract law. So in these circumstances, since if we are the claimant, how could we bear the burden of proof? It's a really difficult questions for us. in this concern, I hope that maybe we can find a feasible way to rebalance the inadequate quality in court between the GNS providers and the victims. So above, we talked about, it's about the 4 elements should be proved the civil liability in accordance with the national law. There are, let's repeat these 4 elements. First one is the parties involved. The second one is unreasonable acts. And the third one is the damages. The fourth one is to prove the carry link between the acts and the damages. So we've finished the part 2. We have finished the part 2. Okay. Okay, time have moved to the 9 o'clock. Do you have any questions about mentioned? Is there any?
There's some question in the chat panel.
Is there?
Yeah, there's some questions.
Yes, please.
Please wait a second.
Okay.
Yeah.
Yeah. Do you have any questions about these 2 parts?
In the chat, you can read it. Dr. Ala Nahri wants to ask a question. Please, Dr. Ala.
We have 5 minutes.
Yeah. Sorry, Dr. Ala. Professor Ala Nahri.
Hello. Hello.
Hello.
It's not clear. Sorry.
Sorry, just a minute, please. There is.
Sorry, I didn't hear you.
Professor Ala Nahri, please.
Hello. Mr. President.
Dr. Ala, please, your question. Dr. Ala.
Okay, do you hear me now?
Yeah.
Okay. This is Ala Nahri, Professor of Remote Sensing at the National Authority for Remote Sensing and Space Sciences. Unfortunately, sound was not so clear at all. But I understood something from your presentation. You spoke about civil liability regarding your national law. What about the international law? Was related to GNSS civil liability?
Thank you for your question. Here I talked about this civil liability in a broader sense, not specific in one nation law, but I extracted some common, something in common, especially some, the 4 elements to prove civil liability to list it here. Maybe there are some differences between the common law system and the continental system, but usually they will involve these 4 elements. Professor?
Yeah.
Yes.
Okay. But the sound is so bad.
شكرا أخ علاء. في سؤال الأخ إبراهيم من الأخ فارس خريس.
تفضل أستاذ فارس.
Still not clear, right?
Yes, please. There is one question from Mr. Faris Khres.
Yes.
Hello?
تفضل.
Yes, I can hear you.
Yes, thank you. Thank you very much, Dr. Kigao. My name is Faris Khres. I hold a master's degree in international law. I am an applicant actually for the 2020 Master Space Law program at Behang University.
Okay.
First of all, thank you very much for this very valuable lecture. I would like to also thank Professor Aouni for his efforts in bringing many honorable scientists such as yourself in order to learn from. I have actually a question regarding state immunity and the liability of the GNSS providers. So could GNSS providers, in this case, release its civil liability or shed away from its civil liability by the doctrine of state immunity if that provider is a public authority? If the company, for instance, who gives the service is owned by the government or is affiliated with the government.
Yeah.
Thank you very much.
I'm so sorry. I didn't grasp your question because of the network. Could you repeat it?
Yes, absolutely. My question is that if that provider is a public authority.
Okay. So
Yes.
let me rephrase your question. Your question is about, because you know the most providers, GNSS as providers are the states, right? Could they raise the state immunity to the civil liability, right?
Absolutely. That's correct.
Okay. So here is the thing. As we mentioned to the state liability, there are about 3 schools of thoughts about that. First one is the about the absolute state immunity and the relative state immunity. It depends where you sue. Okay, if you sued in the USA, maybe the hello. If you
Yes, please continue. Yeah.
okay, if you file a lawsuit in the USA, maybe the absolute state immunity could be applicable. So maybe you can raise the civil liability.
Yes.
But
that's clear. So it depends. It actually depends on the legal system of each state and to what extent we could have, for instance, some form of case law.
Right. Right. So it depends the legal systems and the schools. My next part address. In the part 3, I will address that from the international point of view, whether the liability, region for damage caused by space objects apply to GNSS damages. If it could be applied, whether it is adequate and appropriate. So that's the latter we are talking about. Could you leave this moment for me to address this question later on?
Thank you very much, Professor. I really appreciated your time, and I hope seeing you soon in Beijing. Thank you.
Ionospheric modeler, and I would like first to thank you very much for this interesting presentation, and also I would like to thank the organizer. I have a question regarding the third party and the acts you mentioned, God acts. So like we provide models, ionospheric models and advice, space weather advice to customers. So which one? So are we third party or are we acts of God? Because this includes your part for ionospheric solar storms and solar flares. So we monitor the solar flares and we also model the ionosphere.
Okay, thank you. Maybe your question could be rephrased like this way.
Yeah.
So how to identify the third party, right?
Yes.
Okay.
So like, yeah, sorry. So if we provide,
please.
We provide like the IKU, we are a IKU center. We provide the GNSS advisories, the HF communication advisories, and this all based on models we develop. So say we do something wrong. So what's the situation here?
Okay, for the third parties, usually the third party, as a contract, for example, if in contract relationships, you are consumer and so you are the user, okay, and the other part is
sorry,
right?
I will adjust. Here we are both. We are user because we use the GNSS signals from the GPS, and also we provide. So we are both if you want.
Oh, okay, you are both characters, right?
Say yes, we do.
Okay, for the third parties, usually it will arise from the parts.
Okay.
Mm-hmm. Okay, so do you have any questions?
So the question is, you mentioned the God acts, so they are not like, no one is liable for this one.
Okay,
and we do something for it.
Okay, for the God acts, that's something out of humans' control. You can imagine what kinds of, situation out of human control. That usually would be some disasters, right? Hello? Am I out of line?
Me, okay, yeah. And I'm muted now. So we kind of control the God's acts. We do the models. We monitor the space weather part of it. So we're supposed to know this impact on the GNSS signal.
Okay, so you because you are the scientists, right? You will, this God acts will be foreseeable, right?
Yes.
but for another part, did you can monitoring the all of the disasters?
We kind of, in ideally we are supposed to monitor this.
So that's the question. You are supposed to.
Yes, we are.
But are you sure?
Well, all
sure?
space weather centers like we are.
Oh, okay.
It's not us. There is the SWIPC in Colorado and Sydney, the Space Australian Center. We do the same thing. So we are supposed to monitor the sun for those flares and also the ionospheric changes and anything that's going to affect the GPS or GNSS in general signal.
Okay, so if you can monitoring this kind of things, could you how to say that?
So is that just, is it a third part? It will be a third part.
No.
Okay.
Okay.
Dr. Sattam Shgur, please, your question.
What? I'm sorry?
Dr. Sattam, please, your question.
Just I want to thank you very much for this participation and this very important lecture. I want to ask you to convey to all team our message of thanks operation. Also, and I would like to express my gratitude to Dr. Aouni. Dr. Aouni, he's landable and trials. Thank you very much.
Thank you.
Thank you, Dr. Khatam. Then let's move to the next part, please, Doctor.
Okay. If there is no further questions, I would like.
Just I want to thank you very much, you and Dr. Aouni, for this lecture. It's very important.
Thank you.
Thank you very much.
Okay. My third part, may I proceed?
Yeah,
Mr.
please.
President, may I proceed?
Yeah, Doctor, please.
Okay, thank you, thank you. So my third part is about the evaluation of the international space law, whether or not it could cover the scenarios happened or caused by the GNSS damages. So this is the two questions I would like to address. Till now, there are some sources for international space law concerning GNSS civil liability, but the most important two is the Outer Space Treaty and the Liability Convention. I just want to make it clear here. As for the Outer Space Treaty, Article 7, it could be concluded the launching state bear international liability for damages, damage caused by space objects. So if you want to prove the liability, the first thing is what kind of objects can be identified as the space objects. Is the signals of GNSS could be identified as the space objects? This is the first question I would like to address. And the second one is about the damages. According to the Outer Space Treaty, the damages may be limited to the direct damages, or the physical damages. So could we say that the intangible signals could cause damages? Or this is the second question. And the third one is also to prove the causation between the space object and damages. That's the logic I would be addressed in the letter. Okay. For the definition of space objects, for the definition of the space object, at the time of the, when the liability convention was concluded, there exists no general accepted legal definition of term space object. Although Article 1 of the Liability Convention lays down that the term space object includes components parts of the space object as well as its launch vehicles and parts thereof. Most scholars recognize these provisions as an expression rather than a full definition or a partially definition. For a legal standpoint, it is without question that navigation satellites, including their components, are space objects here, but it's questionable whether a signal transmitted by those navigation satellite could fall within the term space object. As far as this question concerned, there are three opinions. There are three opinions about space object. The first school insists that a space object itself would have both material and physical property, which excludes a signal. This is the first school. The second school argues that damage from intangible electromagnetic waves was not absolutely excluded in the interpretation of liability convention, even though physical damage caused by tangible parts of a space object was of foremost concern. The third school is not popular, but they hold that itself. According to the Vienna Convention, there are 3 elements to be proved, which are conventional language, the context, and the object and the purpose of a treaty. Outer Space Treaty and the Liability Convention, the state practice may be recognized as customary viewpoint of interpreting and adding an intangible GNSS signal to the physical term space objects. Let's take a look here. From the conventional language here, a material thing that can be seen and touched with a fixed shape or form. Article 1D of the Liability Convention doesn't qualify as a definition of the term space object. It indeed may serve as a basis to understanding the meaning of that term. And also the legal subcommittee of UNIVUSA, believing that the term space object had a reasonable, clear meaning, and it was only necessary to emphasize that all the component parts and the launching vehicle devices were included besides the space object itself. In this sense, the minimum requirement of a space object is physical nature, physical one. You can touch it. Otherwise, no component parts or launching devices thereof could be included. This is from the conventional language. And also from the context of the convention, phrases shown a strong implication for the physical needs of space objects, such as the launching of an object to outer space. A space object is launch a space object. The operation of that space object are frequently used, which we can draw a conclusion that a space object is usually connected with launching and operating activities. This is from the whole context of the convention. We can draw a conclusion. There are physical need for the space object. And also let's take a look of the object and the purpose. The purpose of interpretation is to determine the original meaning of terms or provisions so that interpreters may not make new rules or revise the convention without the approval of all contracting states. a treaty must be interpreted under the principle of good faith. It would be inappropriate to read into that provision certain rules so as to reflect what should be, particularly as such rules go beyond the normal meaning within the treaty context as required by the Article 31 of the Vienna Convention. As we all see here, even though the Outer Space Treaty, including its entitled Declaration of Legal Principles governing the activity of space in the exploration and use of outer space, the Liability Convention finally selected the word object, space object. The starting point in their draft documents submitted by the individual member state was such terms as damage caused by space vehicles, space devices, the launching of objects into outer space. Let's talk about it repeatedly. In the drafting documents, the delegates submit some words such as the space vehicles, space devices, the launching of objects into outer space. So those terms in delegations looked into was the civil liability for damage resulting from a physical one, you can touch it, mainly in a space vehicle accident, particularly at the moment of launching rather than the intangible data, application, or product emoting from that object. So in this case, we can draw a simple conclusion here. Both international treaties on outer space, which are the Outer Space Treaty and the Liability Convention, the state practice, there is no evidence to support the viewpoint of interpreting and adding an intangible GNSS signal to the physical term space object. In another word, the GNSS signal is intangible. It couldn't be attributed to the space object. So this is the first conclusion. Okay, GNSS signals is not the space object. It's not the space object according to the Outer Space Treaty. And the second one is about the damage. Remember the word used in the Outer Space Treaty, Article 7, is the damage caused by. Okay, so here we should clarify the damages. What kind of damages could be attributed to the how to say could be what kind of damages it referred in accordance with the international outer space law. Even though the damage here is clearly defined in Article 1 of Liability Convention as loss of life, personal injury, or other impairment of health, or loss of damage to the property of state or of person, natural or judicial, or property of international intergovernmental organizations. Many scholars still insist that this definition is ambiguous, particularly in terms of whether that term includes only direct damage, indirect damage as well. Indeed, during the drafting of Liability Convention, the inclusion of direct damage and the delayed damage was such a thorny question that it didn't result in an agreement being reached. on one hand, the U.S. delegation expressed that the liability convention doesn't cover what some delegations early called it remote and indirect damage. And for those, there is only a hypothetical causal connection with a particularly space activity. So in this case, in this case, indirect damage could be excluded. The last one is about the causation. In order to prove causation, foreseeability and proximity should be proved here. So, what is the foreseeability? Usually, it is in tort law. It is generally required that the existence of type of damage must be reasonably foreseeable by a reasonable person at or before the time the accident occurred. And it does not matter whether the liable person actually expected that damage or not, and whether the extent of that damage has been foreseen. So this is the key words here. This damage must be reasonably foreseeable by a reasonable person. This is the first element here. And also about the proximity. All proximity cause doesn't have a general accepted meaning in practice. Its definition is still in progress with too much disagreement among courts and scholars. Therefore, judges in the court often, instead of determining that whether the damage is not proximate or too remote, it should be noted here that the proximity itself does not exclude all remote cause, but only those who are too remote. Okay, this is the three factors to prove here. Okay, from the explanation of the Outer Space Treaty, we can see that both from the definition of space objects and the damage, and also from the causation, that GNSS signals couldn't be covered by the international outer space law. So this current international space law is neither an adequate nor a fair mechanism for GNSS civil liability. International space law is practicing in gap between the real and idle. Since the delegations of outer space negotiations and drafting relevant treaties, it has been 40 years ago. So the way to figure this out is to explain the treaties, partially the definition of space object in a broader way. So that's all of my presentations. Thanks for listening.
Thank you, Doctor. Please, if anyone wants to ask a question, please raise your hands. Take your question.
Is there any questions?
I see no question. Nobody raises his hand. From tangent, everyone. You can read in the chat from Professor Tian. There is some note.
I'm so sorry. I don't know if you could hear me clearly during this past 1.5 hours. So, yeah, if you have further questions, you may contact me later on.
Thank you, Dr. Key, for your interesting lectures. We are very happy to host you at this lecture. We hope that we will have more and more lectures in this very important issue. Thank you again. Thank you, everybody. And we hope to meet again. Dr. Aouni, do you want to say something?
That's fine. I would like to repeat my highest gratitude to our distinguished actual lecturer. We have enjoyed the time with her, especially this topic, space law. You see, it's not easy for our area, even if for our specialization. I hope that we will be able in the near future that we can make a workshop for 2 days, as we have already performed with Dr. Shian, and we can get more details about this topic. It's very important, especially relating to space, and the importance of that, the knowledge which you have, and the knowledge which you have given us, and we are really very much grateful. And I would like to emphasize to my, thankful to you on behalf of all participants and who is present now in this lecture. And really, I am very much impressed. Also, I have seen Dr. Ala from Egypt. He's actually the deputy of the Regional Center for Space Science Technology. And Dr. Mohammed Zahran, also, he is the head of the remote sensing in Egypt. And Dr. Osama Shalabiya, our friend, and also he is the Dean Faculty of the Navigation College in Cairo University, and others from Jordan, and all colleagues who is actually with us. Thank you very much again. We are very much happy always to see you and see your colleague, Mr. Shian, Professor Shian. Thank you. You have really worked very much hard to make this lecture a success. And I wish you all the best. And for all China and our Jordanian and Arab friendship with China, thank you very much and goodbye.
Goodbye. Thank you.
Goodbye. Thank you for your time.
Bye-bye. Thank you.
Thank you. Bye.
Thank you. I have seen